Hello, my name's Bill Gilbert. I'm one of many Warren Township residents opposed to development on the former Wagners Farm property. A number of us listened to the planning board hearings about this project and argued that development should not happen as the developer has proposed or in any other manner on this particular piece of property. So we were dismayed when the planning board went ahead and approved the project anyway. But the good news is that's not the end of the story. As many people know, attorney Bruce Afran is representing George Vedder in appealing the approval. Mr. Afran is a well-known public interest, constitutional and environmental lawyer in New Jersey, active in a number of cases seeking to block development on environmentally sensitive properties. He's also taught for 20 years at Rutgers Law School. So with that intro, welcome, Bruce. Like most Warren residents, before this project, I thought the property was protected green acres. While I now know that's not the case, I understand the township did purchase the property for preservation purposes. Can you explain to us why that's important?
Sure, Bill. You know, it's a bit of a bait and switch. In 2001, the township allocated money to buy this land. And it's said in the resolution, and that's what the public was told, it's for the purpose of preservation and ecological protection and open space and recreation. And this is really consistent with the whole area in general, which is a natural area. It's part of the county master plan, in fact, for preservation. And this is what the public was told, that the property will be purchased for these purposes. Now, 20 years later or so, the town has agreed to include this site, this 10-acre site, 11-acre site, in its affordable housing component for special needs housing. Now, special needs housing is an important goal, but we have another goal, and that's protecting the environment. We are running out of preserved areas, and we have to be very careful that those areas intended to be preserved are not used for development. So we have two competing goals. One is, yes, we need special needs housing, but we also need to preserve open natural areas. This is actually habitat for wood turtle, which is an endangered species, very rare in New Jersey. And it is a vernal habitat area, which is where amphibians and to some degree reptiles live and breed. And it's a vital part of the ecosystem in New Jersey, much of which has been destroyed. And we can only protect it by standing firm for those lands that were bought for this purpose. And now the town wants to turn it into a major, major development. Now you got to realize this drains right to a river, the Passaic River, I believe it is. Mm-hmm. And it is essentially a wetland. And in order to build this, they have to actually put a plateau and raise it up and create this plateau to house this multi-unit, 40-unit approximately dwelling. It's going to have a community center, it's going to have 4 main buildings, and believe it or not, a sewage treatment plant. And it's on such a sensitive site that they actually have to build it up in order to support it on this wet soil. And so we're facing the destruction of a natural area to build a housing complex. Now we have tens of thousands of housing complexes, but we're running out of natural space. So that's what this case is about. George and Deborah Vedder have led this so far with others, and they've retained me to take on the challenge to the planning board approval. And also, and this is very important, Bill, the challenge to the town's use of this land for this development when it was allocated for ecological preservation.
Right.
And that's the fight.
And as I understand it, there's kind of two different legal avenues there, one relating to the original purpose and a second relating to the planning board itself.
Right, that's actually very, very true, Bill. We have two directions we're going in, but they start here, but they go to the same place.
Right.
We have two approaches. One is we're challenging the planning board's approval. The planning board approved this. We believe that's wrong for several reasons, which I'll go into. And we're challenging in a separate lawsuit the town's use of this land for this purpose.
Right.
And our lawsuit says this land was purchased for the limited purpose of ecological preservation. It is to be used for that purpose, and the court needs to order that a deed be created to restrict its use in this way.
Got it.
Not for use in a major development. It
Right.
will actually destroy a large part of the environment in this area.
Right, right, okay. And then the second one relates to the planning board, you said.
Right. Now, both of
Second
these are very
case.
important.
Yeah.
And the first one, I think is a very, very strong case. The town issued a resolution specifically dedicating this site for a purpose. And there's no other purpose reference. It doesn't even say, as you sometimes see in these resolutions, and for all other public purposes. It simply says for preservation, ecological preservation, and open space and recreation. It doesn't say for other public uses.
Okay.
So the public was told, we're going to preserve this land with our money. It wasn't Green Acres money, as it turns out, but it was
Right.
township money,
Yes,
spent under that specific resolution. That's one approach. I
Right.
think that's a very powerful tool because the
okay,
town has to abide by its own rules. The second approach is a challenge to the planning board's approval on several grounds. The primary one is that they approved a sewage treatment plant in this very sensitive area, and that's not within the uses in the zone. And really a use variance is needed, and that's a very, very difficult thing to get. And the town approved this as if, and what the planning board said, rather, it said, well, this is customary with housing developments. Well, that's not true. Most housing developments don't come with their own sewage treatment plant.
Right.
The other thing is the board gave no real consideration, none really at all in its approval, to the impact this will have on that surrounding natural area. And they're required by law, by state law, to make an evaluation of how this will affect the surrounding vicinity. And they didn't do that.
I see.
So these are the
Okay.
two approaches. I think they're very strong. I can't predict what a judge will do,
Sure,
but I can tell you these are strong legal arguments.
great. And then I understand there's a third avenue with the New Jersey DEP. You mentioned this is environmentally sensitive property and they require that permit from the DEP. Can you tell us about that?
Yes, I'm glad you mentioned that, Bill. That's actually a very important part of this, but it's sort of under the radar a bit because they're on public hearings that people can attend. DEP has to give what's called a general permit to build in wetlands, to build a roadway and access roads and things like that. Those are normally not hard to get as long as you don't intrude too much into the wetland. But when it turns out the wetland is habitat for an endangered species or threatened species and feeds into US waterways as it does, then it becomes difficult to get the permit. So we've demonstrated to DEP through our expert, Susan Quackenbush of Amy Green Environmental Consultants, that this is habitat for the wood turtle and that it feeds into protected US waterways. And we have raised a strong objection to DEP not to give this permit.
Yeah,
Now,
I see.
if we win with DEP, then that's the end of it. They can't do this. If we lose with DEP, we can take an appeal to the appellate division. And it's a separate proceeding, so that's a third process.
Yeah, I see. So, yeah, you mentioned appellate. So you've mentioned you mentioned the DEP and these separate legal challenges. Knowing that this process takes some time, what's your ballpark estimate of how long all of that could take to get resolved, including potential appeals?
Well, it's not quick. It doesn't take 10 years either.
Hmm.
Basically, our case in the planning board will be served probably later this week. At that point, the town has 35 days to answer, and the planning board too. After that, the judge will schedule briefing schedule. Probably 90 days later, we'll have briefs filed. The judge will hear oral argument probably in, say, 120 days from now, maybe 150 days. That's 4 months, 5 months. And after that, if either side can appeal. If we win, the project is stopped dead in its tracks. And then the developer and the town are going to have to take an appeal to the appellate division. If they win, we can take that appeal. And I can tell you that we have strong grounds for an appeal. The appellate division in cases like this actually has the same jurisdiction as the original trial court. So if we lose, we start all over again in the appellate division. So this process goes on for 2 to 3 years.
Okay.
And, in that time period, Bergen County United Way may say, look, we'll build our house somewhere else.
Right.
But we have a very strong legal challenge to make.
Good.
And this can succeed. Remember, we only have to win one of these. They have to win everything.
Oh, that's an excellent point. Yes, yes. Well, those of us, trying to support your efforts, and George and Debbie and everyone, as you know, have started a GoFundMe to raise the funds to support your legal efforts here. Can you give us a sense of, again, a ballpark of how much money is going to be needed to follow the process you just outlined?
Well, if we stay in the trial court, I think we're talking probably about $18,000 to $22,000. If we have to go up an appeal, we're probably talking another $16,000 to $17,000.
I see.
In addition, George and Deborah have ordered, or will be ordering, the transcript from the planning board hearing, and that does cost about $4,500. That has to be done. There's no choice.
Right.
So we're talking about a budget of probably $25,000, maybe going up to about $38,000, $40,000, something
Okay.
in that general area.
Okay.
But that's the higher end is really if we take an appeal.
Right.
The lower end, we can do this case for about $20,000 to $25,000.
Okay. Great.
And George and Deborah have already laid out some money. But it's
Yes.
very doable. People have to realize something. Law is very strong when it comes to protecting these properties, these natural sites. And a strong legal challenge has a great chance of success.
Sure.
A lot of people say, oh, it's a done deal. It's not. The courts will look at this fairly, and it will be heard in a fair and neutral proceeding. I have done many of these. I've often succeeded for clients. I stopped a substation being built on what's called the Princeton Nurseries land in South Brunswick, New Jersey, a big natural area. And my clients objected to this 7.5 acre substation being constructed right in this really open natural place, connecting to natural areas, just like this Caldy's Crossing site does. And we stopped it. We were in litigation for 3 years, and we eventually got a court order blocking the project. And one can succeed with this. And it really happens frequently that there are changes in these plans or they die.
Yes.
So I would say to people, if you want to protect this land, invest some money. 10, 20, 30 families together can each put in a modest amount, and we have a very good war budget. And the courts will be fair. They are not going to be biased in favor of the town. They're not going to be biased in favor of United Way. They will hear the case fairly. That I can assure you.
Great. Bruce, that's very encouraging news. Thank you very much. Really appreciate your time today. I really believe your efforts are widely supported throughout Warren Township, and that by sharing this message you've outlined for us today, that we'll find many more enthusiastic supporters to help support the cause, both financially and otherwise. So again, thank you very much for your time. Have a great day.
Thank you, Bill. And let me just say to people that if you don't fight for this land, you don't get to keep it.
Well put. Thank you very much.